Hi, I'm Chris Devlin, an associate in the corporate team here at Bristow's. In this short video, I'll be discussing the typical structure of a transaction involving an equity investment into a company. And I'll also be suggesting some of the things founders should be thinking about throughout this process. By equity investment, we essentially mean when an investor injects money into a company in exchange for an agreed shareholding stake in that company. The early stages of negotiating an equity investment will typically involve some relatively high-level and informal discussions between the investor and the company. During these discussions, headline topics could include the appetite of the company to take on investors, the shareholding stake which is available, and the basis on which both parties are valuing that shareholding stake. From the company's perspective, it's important to consider whether at this early stage the potential investor will be receiving any sensitive information concerning, for instance, the company's business or any of its key clients. If this is the case, the company might consider whether the investor should be required to sign a non-disclosure agreement which will cover the information it receives during the course of the negotiations. The company's lawyers can draft this agreement if it's required. Another key thing for the founders of the company to think about at the outset is whether there are any particular consent or anti-dilution rights which other, perhaps smaller shareholders in the company may have within the context of a new equity investment. It will be important to discuss the parameters of the potential investment deal with these other shareholders and to try to get them on side as early as possible to provide the required consents which they will need to give later on in the deal process. The company and the investor should also discuss their particular expectations around when the transaction should be completed. In our experience, it can take anything from a couple of weeks to several months to complete an equity investment, and the parties should be aligned on timings from the initial stages in order to ensure the deal is able to maintain momentum. A timetable to completion is often a quite useful document to have in circulation at this early stage. Delivery of a draft term sheet is usually the next step in negotiating an equity investment. This can be drafted by either side, but it will usually take the form of a letter from the investor to the company setting out the commercial terms of their offer. Such terms will include the number of shares they're offering to subscribe for in the company, the consideration or price which they're offering to pay for those shares, whether they will expect the company to give warranties or any special indemnities around the current state of affairs of the company, and whether they would expect the key people within the business to be subject to non-compete or non-solicitation covenants. The term sheet might also include any veto rights which the investor might expect over the taking of key decisions in relation to the company. The company will then review the term sheet served up by the investor and, together with its lawyers, will suggest counterpositions to the terms being proposed. This will include a response to both the headline terms proposed, such as level of shareholding and the price, but it can also, for instance, may be a suggestion that any warranties and indemnities to be given by the company in the investment agreement will be subject to caps on the overall financial value of claims or time period caps within which claims can be brought. Whilst most clauses of a term sheet, other than, for instance, those dealing with confidentiality issues or exclusivity, will often be deemed to have non-binding legal status on the parties, these terms will form the commercial scope around which the parties will negotiate the transaction going forward. And therefore, it's helpful for the point of view of the prospects of getting the deal done if many of the more contentious issues of the transaction are ironed out during this initial term sheet negotiation phase. The offer provided in the term sheet will often be subject to completion of the investor's due diligence. Therefore, the next key stage of an equity investment process will be this due diligence. It's basically the stage where the investor and their lawyers will review the company's books and materials in order to evaluate the business. There could be significant administrative burden during this phase for the company and its advisors, since they quite often will be tasked with reviewing the investor's due diligence request list and gathering the various information and documents which are requested. They'll then share these with the investor, often by way of uploading all the relevant materials to an online data room. The company should keep in mind and be properly advised during this phase in relation to data protection issues, particularly the uploading of sensitive information, sensitive data, such as in relation to its employees. To the extent the investor identifies any problems with the company during its due diligence investigations, they may seek to negotiate a change to the price they are paying for the shares in the company, or they may seek to include specific contractual protections if an anticipated problem arises. In very extreme cases, if due diligence reveals a number of fundamental issues with the company, the investor may prefer to walk away from the deal altogether. So, assuming that a term sheet has been agreed and the buyer is happy with the findings from its due diligence, the parties will progress to negotiation of the various required core transaction documents. The main document will be an investment agreement, which is also known as a shareholders agreement. And basically, this document will feature all the key terms of the investment as established in the term sheet and which may by now have been affected by the investor's due diligence findings. As with the term sheet, the investor's lawyers will often prepare the first draft of this agreement to send to the company to review and mark up. Other key transaction documents, which might be part of the transaction, depending on the commercial context, might include, for instance, new service contracts for the founders or other key persons within the business, new articles of association to govern the company, plus an agreed business plan for the company for the period post-investment. Another significant document from both parties' perspective will be the disclosure letter. The disclosure letter typically takes the form of a letter from the company to the investor, which sets out details of any exceptions to the factual statements about the company which are provided in the warranties of the investment agreement. Normally, if a warranted fact given by the company in the investment agreement turns out to be untrue, the investor would have a claim against the company for breach of contract. However, no such claim can be brought if the facts which gave rise to the breach have been disclosed to the investor in advance. Therefore, from the company's perspective, the disclosure process presents a vital opportunity to reveal potential inconsistencies or historical issues of non-compliance by the company without facing the risk of claims being brought by an investor in these circumstances. From the investor's point of view, the disclosure process will present another opportunity to learn as much as they can about the business they're proposing to invest in and to renegotiate the transaction terms, or, in extreme circumstances, as we've mentioned with the due diligence process, they may choose to walk away from the deal altogether if particularly problematic issues are revealed. Therefore, it's sensible for the company to work with its lawyers, ideally in advance of due diligence, but certainly in advance of the disclosure process, to rectify or mitigate any potential problems with the business in advance and make it a more attractive prospect and ultimately worth a higher value to a potential investor. The disclosure process is the last key stage to undergo before the deal itself can be signed, the company can receive its cash injection, and they can welcome the investor as a new stakeholder in their business. So, this has been just a very brief whistle-stop tour through the key phases a company will typically encounter when negotiating an equity investment. For more information on this process, or if you would like to have a confidential discussion on the key things a company or founders should be thinking about when planning to take in equity investment, please feel free to get in touch with us in the Bristow's corporate team. Our details can be found here on the cookie jar or on our website at bristows.com. Thanks for watching.